Hey, Dr. Darko, where do you go to get your life and disability insurance?
I went to Set for Life Insurance. They helped me save over 30% compared to my previous policy.
Wow, I'm paying an arm and a leg for my life and disability insurance. What's that company called again?
Set for Life Insurance. Check them out at setforlifeinsurance.com and tell them Dr. Darko sent you.
Welcome to Docs Outside the Box podcast. This is your official show, looking inside the minds of cutting-edge and innovative doctors. Think you'll find these stories in any medical textbook? Sorry. You're getting real live insight from men and women pushing the envelope beyond medicine. Ordinary doctors doing extraordinary things. Let's start now with your host, Dr. Nee Darko.
Hey docs, are you looking to learn how to become a physician leader? Then Physician CEO is for you. Physician CEO is an accelerated business immersion program designed for physicians and developed by MBA faculty from the Kellogg School of Management at Northwestern University. So learn more at www.physician-ceo.com/DOTB. What's good, everyone? This is Dr. Nee Darko. Thanks for joining me on another episode of Docs Outside the Box. I hope you all are enjoying this summer heat. I really enjoy summertime. It's one of my favorite times of the year. As a matter of fact, it is my favorite time of the year. Brings back so many different memories from growing up in Queens, New York in the 80s and then moving to New Jersey and just having so many memories with, opening up fire hydrants and then later on having the firefighters come by and close them all up and stuff, and so many different heat waves and blackouts. Is just a bunch of nostalgia that comes up with the summertime and all the heat waves. So that's why I love the summertime. The other reason why I really like the summertime is, as a big NBA fan, I love NBA free agency. And I got to give big ups, congratulations to the Los Angeles Lakers, Magic Johnson, for picking up LeBron James. That's a huge pickup for the organization. And as usual, my Knicks did diddly squat. They didn't do anything. And look, before I start going off on a tangent, let's just move on. Before we go to our next episode, please make sure you go back and check out episode 61 with Dr. Wendell Cole. Once again, Dr. Wendell Cole is a newly minted physician who is doing so many different things. He's a triple threat podcaster, physician, and also business entrepreneur. He has a podcast that is called Convos with Cole, which is really good. I think you all should check it out and take a listen. In the show notes, I put a couple of his favorite episodes up there. And then we talked about his book, which was just released, and the giveaway that's associated with it. So make sure you go ahead and listen to the episode and find out how you could be entered into a free giveaway. But overall, impressive man, and I just want to wish him good luck during his orthopedic surgery residency down in Tulane. Now, for this episode, if you haven't heard of this case, you definitely have been living under a rock. On this episode, we're going to be talking about the case of Dr. Draion Burch versus Andre Young, also known as Dr. Dre the Rapper. And this has been going on for the past 2 or 3 years. And earlier this year, the verdict came in, and the United States Patent Office sided with Dr. Draion Burch. And if you didn't see it, it was all over social media. It was on TMZ. It was all over electronic and print media, and definitely a victory for doctors and definitely a victory for people who want to protect their name. So on this episode, we're featuring the lawyer of Dr. Draion Burch. Her name is Andrea Evans, and her focus is on intellectual property. She's a heavy hitter. She definitely knows her stuff. So very briefly, she got her law degree from the George Washington Law School. And at one point, she was a former patent examining attorney at the United States Patent and Trademark Office. So we talked about, in essence, the general specifics of this case, which is really shocking and interesting from an outside perspective looking in. But on this show, I want you guys to learn not only the specifics of this case, but for all of you creatives out there, and by creatives, I mean anybody who's creating content. If you're on YouTube, if you're a podcaster, a blogger, whatever it may be, this is an episode that you want to pay attention to, because some of the things that you're going to learn on this are, we're going to talk about the specifics between what a trademark is, what a copyright is, and what is a patent, talking about the importance of protecting your brand. We're also going to talk about what a cease and desist letter is and what you should do once you get this letter. Really important also is Andrea is going to talk about the pitfalls with taking the do-it-yourself approach to protecting your intellectual property. And we're going to use my podcast as a case scenario on why and all the different layers in which you should protect your work. And then she's also going to give some advice on how to create a very strong trademark. So like I said, for all you creatives out there, or just people who just want to hear about this interesting case of Dr. Dre the rapper versus Dr. Draion Burch, this is going to be a really good episode. Make sure you get a pen pad and make sure you share this episode with others. And without further ado, I present Andrea Evans. Andrea Evans, welcome to Docs Outside the Box. How you doing?
Thank you. I'm so excited to be here. Thank you for having me. I'm
really excited to have you on here, but I'm sure you are a little tired of doing the whole circuit because of what's been going on with Dr. Dre and representing him. So thank you for taking time out for being on the show.
Thank you. I'm not tired. I'm excited. I'm energized. Let's talk about it.
Well, from a doctor standpoint, we're excited for this case also. So, I think a lot of people heard about this case, obviously from the conclusion standpoint. They didn't know what was going on because, obviously we saw it on TMZ. We saw it on a whole bunch of different news outlets. Basically, Dr. Dre versus Dr. Dre, so to speak. Can you tell us a little bit about the specifics of what went on with this case? I know Dr. Dre, he's been on this show 2 times already. He was in a legal battle with the rapper Andre Young, but can you give us a little bit of the specifics about it?
So essentially what happened is Dr. Dre, so Draion Burch, affectionately known as Dr. Dre, decided to file for his trademark application. So his trademark application was for his design mark, Dr. Dre, that has his logo and kind of symbols and everything, and also his word mark, Dr. Dre, D-R-A-I. And so when you file a trademark application, you have to identify all the goods and services you're either using that trademark on or intending to use it on. So he identified all these different goods and services, including speaking and training and books, but all of them were really tailored to the medical field. Well, once you file a trademark application, it goes through the process where the government does a search. So they didn't find anything confusingly similar. But when the government doesn't find anything confusingly similar, they publish it for the public to challenge you. And so during that publication period, we heard from Andre Young's counsel, and they basically said, hey, cease and desist. We have a problem with this. We don't want your client to proceed being Dr. Dre as this brand for these different goods and services. And that's what really started the case. So they sent the cease and desist letter. We kind of went back and forth trying to negotiate, and that didn't work. And so Dr. Dre pressed it, and we went all the way to the end and had a victory. So essentially they sued for what we call likelihood of confusion. And it's good to talk about that a little bit because that's probably the most misunderstood thing in trademark law. Likelihood of confusion is just what it sounds like. It doesn't have to be actual confusion, only a likelihood of confusion. So basically they're looking at comparing the marks and then comparing the goods and services and saying, hey, would anyone in the public be likely to be confused by this? So of course we said no. Even though the marks kind of are pronounced the same, they don't have the same appearance, they don't have the same spelling. And this just getting past the marks, when you look at the services that our client, Dr. Dre, was filing for, when you think of medical services and you think of production services, they're not related at all. And so the first challenge was likelihood of confusion. And then the second challenge was Dr. Dre, Andre Young, was challenging our client saying, hey, it's going to be a false connection. And that means that he was saying that people would see Dr. Dre, the doctor, and say, hey, you're associating with my brand and trying to make a profit off of my Dr. Dre producer brand. So they failed with both of those arguments, and we succeeded. And our client, Dr. Dre, Draion Burch, is going to move forward and continue to grow and expand his brand.
And that's very promising, because from a lay standpoint, and if I may ask the question from a lay standpoint, like, how is this able to even see the light of day? Because the names are spelled differently. He's a doctor. Dr. Dre, the rapper, is not a doctor. Like, how is there even confusion? It's not medical related whatsoever, or educational related. Obviously one is speaker. Like it's from my standpoint, and I think from a lot of lay people, it's just like, this is really confusing, and it's really, frustrating that this had to go this far.
Well, that's the beauty of having a trademark. Honestly, you do have a right, and it is up to you once you get the trademark to police and enforce your trademark. So there's always two sides of every story. So of course he has Dr. Andre Young owns the trademark. And normally, what's so interesting about this case is normally we know that celebrities don't necessarily make all the products that they license their names on. So, Oprah may have soup, and we know she may not be in the kitchen cutting up, things. And so licensing is a big deal with celebrities and their trademarks. And so one of their biggest arguments is that, hey, I'm a celebrity, but the board, the Trademark Trial and Appeal Board, agreed with us in saying that you can't license your name to someone to be a professional, specifically a medical doctor. And your audience knows, and I know you know, blood, sweat, and tears, all the hard work it took to become a doctor.
Right.
You can't just say to me, oh, Andrea, I'm going to license my name and then you be a doctor. I have to go to school. I have to get training and I have to be certified. And so what's unique about this case is the board said, hey, Andre Young, you don't have any proof that you've ever licensed your name for things like this, maybe on headphones and other products, but it's not likely that you would even be able to license your name for a service like being a doctor and providing these types of services, all related is to the medical industry. But more importantly, no one's going to think that it's you in the first place. So
right.
We joked and said, Dr. Dre, the gynecologist, I would love to see him when I'm delivering a baby, but if I go into the hospital and see Andre Young, right.
Right.
But he had a right to actually file and pursue it, because once you get the trademark, you don't necessarily have to wait for the trademark office to police it, because they don't do that. So again, they did their search at the trademark office, and we did a search, and we didn't see anything that we thought would cause confusion. But now he thought it would. And so during that publication period, the public can challenge you and say, hey, this seems like it's too close to mine, or they could challenge it for different things. So he had a right to do it, but he didn't succeed.
So I'm going to continue down this lay pathway, because I just don't, some of the stuff I don't understand. And I really, this is so interesting. So just as a dumb question, like, is this like something that happens in court? Like, are you guys like, is there a judge and you guys are in the same court at the same time? Or is this something that's kind of litigated over paper and then it goes to, one place, it gets litigated and then it comes back and you guys get a judgment?
Well, that's a great question. And there are no dumb questions, because everybody, the thing about trademarks is there's so many different myths and misconceptions. So I'm really happy to be here to talk about it, because I'm hoping that this interview is going to inspire your listeners to make it happen for themselves, start filing and protecting their brands. But the way that it works is trademarks are federal. And so that allows you to use your brand and use whatever you file in all 50 states. So that's putting others on notice that you own the rights in this. And so you file your trademark application at the United States Patent and Trademark Office, USPTO. And so once you file it, it's assigned to an attorney at the office that does this research. And I actually worked as a trademark examining attorney at the office, so I'm very familiar with that process. But when they don't find anything and they publish it and then someone challenges you, when they appeal it to what we call the Trademark Trial and Appeal Board. So that board is made up of different judges, and judges are assigned your case kind of randomly. And just like if you've ever been sued in court, any type of court, they have different rules, but they also give you a schedule. And the schedule says, okay, this is when your discovery conference should be. This is when discovery starts. This is when discovery ends. And so it's a very long and kind of drawn out process. The back and forth of, maybe even trying to negotiate and settle it can cause you to suspend the case. So, the timing and different things can change. So we were basically going back and forth for about 2.5 years. But during the discovery process, that's when you get all your information to basically your evidence that you're trying to basically prove, your case. So you can request information in writing back and forth, but you also have the option to basically have a deposition. So we brought Dr. Draion Burch here to our Maryland office, and we had a deposition to get all our facts. And, Andre's young counsel was there, and they were able to cross-examine. And then,
really?
Yes, we took all that information. Oh, yeah. So just like any other lawsuit, this is before the Trademark Trial and Appeal Board, and we needed to build our case. And so we had the option to have what we call an oral hearing, where you can go before the judge and present your case, but we didn't think it was necessary. So they wrote their brief, we responded, they were able to respond to our brief, and then we just sat back and sort of waited to see what was happening. So imagine that email, when I saw that email, I was really excited and kind of scrolled down because it's a very long opinion. So if your listeners get a chance, I definitely recommend that you read the full opinion because it's very not only entertaining, but educational and informative.
I will put that in the show notes so that it can be easily clickable and they can read that. So take us through the moment when someone gets a cease and desist letter. First of all, what is a cease and desist letter?
A cease and desist letter is simply what it sounds like. It is a letter, but it's putting you on notice and basically telling you, hey, I own this trademark. I think there's some confusion here. You're using it, and someone may think that you're trying to either make a profit off of my name, or someone may be confused as to the source. So basically stop using it. Now, what happens when you get a cease and desist letter is very important. Even if it doesn't come from a lawyer, when someone puts you on notice, and let's say you maybe honestly didn't know, but you continue to use that name, you can be liable for 3 times the damages. So
3 times the damage. Wow.
Yes.
Okay.
So it can be considered intentional infringement. But I also have to tell you that, you want to make sure that before you respond, you don't want to back yourself into a corner and, basically say something that can hurt you in the long run. You definitely want to consult a qualified trademark attorney like myself, because you can jeopardize your rights. The beauty of hiring an attorney is this is business. We know the law. We're going to defend and represent you based off of the law and give you options, because I've had clients receive cease and desist letters and we respond back and find out, hey, you don't have any rights in this trademark. We're going to take your trademark. Or some of my clients have received cease and desist letters and it's for their own trademark. They realize, hey, you didn't know that I own the trademark, so now I'm going to challenge you for it. So you definitely want to take them serious when you get them, and you don't want to be on the opposite side where you get a trademark and you're just going to Googling every single person that has your name, because it's not so straightforward. So even when you get a trademark, it can be considered invalid. So you want to make sure that you sit down with a qualified attorney to explain your options. But essentially that letter is putting you on notice, basically saying, hey, stop using this, and giving you reasons why you should stop. And
I'm sure to the layperson, or even to anybody who for the first time gets a cease and desist letter, it's got to be pretty scary to get that. So staying within this same vein, there are a lot of people who are listening to the show who are creatives. They're starting their own, let's say, podcasts, YouTube videos, Instagram, blogs, basically things that they want to protect, right? They should be thinking about protecting. There's a lot of confusion with, what's a trademark, or what should they trademark versus what should they copyright versus what should they patent. Can you give us a quick tutorial on like how to differentiate between the three, and, what type of content creators should be doing which one?
Yes, and everyone has some type of intellectual property. So intellectual property is divided into 3 types: patents, trademarks, and copyrights. So simply put, you would patent an invention, trademark the names of those inventions, and copyright written material. So that's a good way to keep it straight. So you're going to patent the television, trademark Sony, the brand of that television, and then copyright the scripts, maybe Power.
Okay, now I get it. Okay.
So that's a good way to keep it straight. And that's
You said Power?
Oh, yes.
That's my favorite show.
Okay, well, hey, we're on the same page here then. So, but definitely, you talk about power. There's so much power in intellectual property and in protecting them, because I like to basically educate my clients to be on the side of being more proactive than reactive, because if it's yours and you own it and it is your name, and let's say you're listening and you say, oh, I've been in business 15 years. It's my name. No one's going to take my name. I made up my name. Guess what? It's going to cost you more to enforce that name once someone does take that name. The courts don't take your word for it. It's litigation. So you have to go back and forth and prove it, and that's going to cost you. So I like to tell people the first thing you want to do, even when you start a business, or if you're listening and you feel like you have something, is sit down and schedule a confidential consultation. So that's going to help you to understand your options. First, what type of intellectual property do you have? What are my options? How strong is my brand? These are questions that you want to ask yourself and consult with an attorney, because there's strong trademarks and they're weak trademarks. So the stronger trademarks may be a word that you make up, Google. It doesn't mean anything in the dictionary. And then we go down the spectrum to words that mean things in the dictionary but are arbitrary. Apple for computers. We know Apple means something, but it has no meaning regarding a computer, no relationship or anything. And then we go down the spectrum to words that are descriptive. But these are things you want to think about as you are creating your brand. And then, of course, everyone has some type of copyright. If you're taking notes while you listen to this podcast, that note that you take can actually be protected with the federal copyright. And
so for example, like if I transcribe these episodes, that could be copywritten.
Yes, and
or it should be copywritten.
Yeah, videos and all the podcasts that you create. When you finish this, you can upload it at the Library of Congress and protect it. And the reason that's valuable is because if I then take this and I start charging people, hey, listen to my podcast with Docs Outside the Box, is $10, I'm using your video. And so I'm making a profit off of your copyrighted material. And here's the thing about copyrights.
You just blew my mind on that one. Wow.
Well, you own it as soon as you record this and put the pen to paper, you own it, but you need to register it, because you can't sue someone for infringement until it's registered. And guess what? If it's registered before they copy it, you get more damages. And so you don't want to wait and scramble to register something after someone takes it. You want to be proactive again. So the key with this is when you have things, you want to act on it right away and understand your options. I have so many people that call and say, I have a great invention. I've been sitting on it for 10 years. My question is why? Because it's not the first to invent. It's the first to file an application. So you want to get these things in. It's the first to file for patents. It's the first to use for trademarks. And then for copyrights, you want to try to register before you publish it, if you can, before you make it public.
Wow. You just mind blown right there. I think the audience is going to learn a lot from that, because it's, we, particularly a lot of, doctors or even anybody who's just creating stuff, we're not really thinking about what would happen if someone else came up with the idea, and you don't think about it until it actually occurs. And you're like, well, what could I do to protect myself? And it's too late. Oh man, that is a really, really good point. Overall though, now, is there, like when you talked about the weak trademarks versus the really strong trademarks, just to explain that again, you're talking about, for example, like using like words that are already in existence, like Apple. Can you explain that part again?
Okay, so there is a spectrum of trademarks, and so they go from strong to weak. So we know that we cannot trademark generic words. So you won't be able to trademark medical services for medical services, shoes for shoes. So when you think of a brand, you may not want to, think of a generic word. But you and I know that if I say my business name is Andrea, sometimes I have to add a generic or descriptive word to that name so you know what it is. Okay, my business is Evans IP Law. And you may say, oh, what's that? So I may come up to you and say, oh, I'm Evans IP Law firm. So then you immediately know, oh, you're a law firm. Mm-hmm. So then you have parts of your trademark that are stronger than the others. So then if someone came behind me and they wanted to be Evans IP Law Office, the government's going to say, hey, the dominant feature of this trademark is Evans IP Law. So we're going to compare those two words together and look to see who will be able to get the trademark. So you can't just add another kind of weak word to my trademark. So I want to make sure that people understand that, because often people will say, oh, I'm Docs Outside the Box. Well, now I want to be the Docs Outside the Box. A Doc Outside the Box. That's still confusing. And the golden rule is to really step back and ask yourself, would you be confused? We're already all experts in trademark law because everybody spends money and buys something either online or in the store. So if you saw Oreo cookies and then saw the Oreo cookies or Oreo with a Z, you would be confused by that. So as you're creating brands, you want to make sure you look to see that if you have a word you made up that doesn't mean anything in the dictionary, 9 times out of 10, it should be available because you created that word. So that's a strong trademark. It doesn't mean anything. We think of Google, and then we think of words that mean things in the dictionary but have no relation to your business. So apple for computers. We know apple in the dictionary is a fruit, but it doesn't mean anything related to computers. So that's another way to think about it. So essentially get a search done. That's the bottom line before you launch. So that way you're not canceling website subscriptions, or you're not actually destroying hundreds of widgets that you would have made with a name that's really someone else's.
This is really, really a great episode, and we learned a lot from you, not only from what happened with Dr. Dre, which put everybody, I think all creatives, on notice, but also at the same time, all the knowledge that you gave us afterwards, which lets us know that we need to really do a good job of protecting our intellectual property. So for all the listeners who are listening right now, if they are looking to work with someone, if they want to work with you, how do they get in touch with you if they want to protect their IP?
I am at Evans IP Law all over social media. So you can follow me at Instagram, YouTube, Facebook. And then if you're interested in scheduling a consultation, you can go to evansiplaw.com and click on the Contact Us form, or you can send an email to info@evansiplaw.com, or you can go old fashioned and just call the office at 301-497-9997. And also, if you want to text to join, you can text Evans IP Law to 444-999. And I'm really excited, Dr. Nee, about my new book.
I was just about to say, I was like, you're being kind of modest. There's something else you need to talk about.
I definitely want to encourage you all to get the new book, all about inventing everything you should know, you need to know from a patent examiner and patent attorney. And, you know, I've worked at the patent office on the patent side as a patent examiner, as well as on the trademark side as a trademark attorney. And now having my firm for 11 years, I've seen a lot of different things. And I definitely wrote this book to be a resource to people so that they don't go in blind. And then the beauty of it is, if you pre-order the book, you'll actually get a free trademark ebook about 5 steps to creating and maintaining a strong brand. So you're going to really get a 2-for-1 here with learning about patents as well as creating and maintaining a brand. So if you're out there trying to brainstorm, the ebook is a good tool to help you say, oh, maybe I shouldn't use this name, and kind of take some notes as you go and answer questions to create a strong brand, and then what to do once you have that brand.
Love it. Love it. And I will put that link for pre-orders in the show notes also. So Andrea Evans, thank you once again for your time. This was really an eye-opening experience, and we definitely learned a lot. Hopefully I never have to contact you, if you know what I mean. Because full disclosure to the listeners, I have worked with Andrea Evans for trademarking Docs Outside the Box. So it was a very, very great experience, and I feel that much more better and more protected knowing that the name Docs Outside the Box is trademarked. So.
Well, thank you. And to all the docs that are outside the box, you all have some type of intellectual property. So I hope that this is the spark that you need to move forward and start protecting your intellectual property. And then once you get it, make sure you're enforcing and policing it. So thank you again for this opportunity.
This was great. Awesome. And that's a wrap. I hope you all learned a lot from this episode. I definitely learned a lot. And decided to take action and protect my intellectual property with the podcast. So make sure you share this episode with others if you think they're going to learn a lot from this. And also at the same time, please leave a review on Apple Podcasts. It really helps the show to grow, and it helps the show to move up the rankings, and makes it easier for new people to discover the show. So look, I'm going to catch you all on the next episode. But before we jet, remember one thing: we only got one life. Let's make it count and live outside the box. Peace.